Just a quick little introduction about myself. I am a DePaul alum. I'm currently Associate General Counsel at the Trade Desk, focusing on product and privacy advisement. I will give my little lawyer disclaimer. Everything I say are my own statements and not that of my company. I'm sure you hear that in every presentation, but we can go ahead and get started. So just a quick agenda for today. Privacy as an area of law has grown significantly over the past decade. We'll talk a little bit about GDPR later. I think prior to that, only certain industries really focused on it. GDPR was a big driver that made everybody start to think about privacy. And as we'll go through some of the changes in state and global privacy frameworks, we'll see why that change is still being driven today. Now, every industry and company is kind of focused on privacy in some way. Especially with the constant influx of new consumer technologies and new laws, the need for privacy attorneys is growing. So if this is an area that you are interested in, it's a good job market. I'll give a quick overview of how we got here with privacy law, including some core principles. We'll talk about US federal and state frameworks, global privacy laws. I'll touch briefly on some data security and AI issues. And since this is a boot camp, you guys have to work too. We'll do some hypotheticals and have some time for discussion. I think this will be really boring if I talk to you for an hour, so please ask any questions that you have throughout. All right. So let's get started with what is privacy. Privacy is the right to control your personal information and understand how it's collected, used, and shared. So the appropriate use of personal information is going to vary under the circumstances. So think about going to your doctor and you give your doctor your medical history. He can use that information to treat you. That's why you're giving it to him. So that's your personal information and you're giving it to a doctor. It'd be highly inappropriate if that doctor, without your consent, turned around and sold that to a pharmaceutical company so then they can start selling you a drug. So you can kind of see how the same information in different contexts has an appropriate use and an inappropriate use. There's also some key tensions coming up within privacy law. So the idea of what you can do with your data and then the impact that that has on some other industries, such as innovation. When we're training AI, that requires a lot of use of personal data. Developing new technologies that also may use some of your personal data. In the commerce space, we're seeing a move toward an increased enforcement in antitrust laws. And there is some tension between privacy and antitrust law. So for example, who is familiar with third-party cookies and what Google's doing there? Okay, so cookies are placed on a website so that the website knows that you've been there. So you have first-party cookies, so the website that you're on owns those cookies, and then you also have third-party cookies placed there by a third party. So for a long time, Google said it was going to phase out third-party cookies when you use Google Chrome. So that was driven by a privacy initiative. If you don't have third-party cookies, these third-party websites can't track what you're doing when you're in your group on Google Chrome. Now that Google is facing a lot of antitrust enforcement in different cases, they kind of backed away from their statement that they're going to remove third-party cookies. So now you have this tension of what could have been seen as privacy protective was against antitrust enforcement. And so now you have that dynamic at play. And then you also have some security issues. So privacy requires security, but security on its own could actually violate users' privacy. Think about employee tracking technology on your, if you work for a company, on your company issued devices, so they can see everything you're doing. That's a security feature, but it also impacts your privacy. At the same time, privacy needs security in how it's going to protect that personal data. We'll talk a little bit more about that when we get to the core principles. There's also a big carve out in national security or in privacy laws for the protection of national security. So you'll see this in GDPR where they'll have member states GDPR does not impact the EU member states' national security laws. An interesting play is we'll talk about when we talk about data transfer mechanisms, a lot of the cases where people are challenging sending EU citizens' data to the US are challenging it under US national security laws. And we've had transfer mechanisms invalidated. So where the EU is saying, hey, US, your national security laws don't protect privacy. We're not allowing data to be sent there. You get the same thing in the EU. They're like, well, we're not touching your national security laws. So that's another dynamic at play. Okay, so we'll go into the history of privacy, and this is a very condensed history of privacy. But the idea of privacy as a legal concept really came from a Warren and Brandis Harvard Law Review article in the 1890s. So fast forward all the way until 1948, following the Holocaust and the atrocities that happened there, we had the UN Declaration of Human Rights, and this kind of gave a global recognition of privacy. Into the 1970s, we have some US federal privacy acts, the Fair Credit Reporting Act and the US Privacy Act. And these are some early data protection regulations, but they really focused on what the government can do with data. So how is the government collecting your data? How is the government using your data? Things like that. And then in 1995, we had the EU Data Protection Directive. Does anybody know the difference between a directive and a regulation in the EU? Yeah?
Is a directive just a goal and a regulation rule or guidelines for such goal?
Not quite. So a directive is kind of like an outline of what we want the law to be, but it's up to each member state in the EU to enact their own version of that law. So you could have a directive for anything. It's not specific to privacy. But this led to a patchwork of laws in the EU. So Spain implemented the directive differently than France, which implemented it differently than the UK, because they were still in the EU at this point. Whereas a regulation is much more prescriptive of what that law needs to look like. And it actually says, these are the specific places that member states can deviate when they implement their own law. So 1995, we had the EU Data Protection Directive. Again, this was a very big patchwork of different laws. It was very hard to apply a common standard across the EU. So that takes us to 2016, where we got the General Data Protection Regulation. So this was much more prescriptive. This said, each state must implement a privacy law, must have all of these parts, and then there are very few instances where you can deviate and kind of have your own specific requirements in that area. And then beyond 2016 and 2018, we had the California Consumer Protection Act. So this was the first major state US privacy law. And now we're just seeing more laws popping up related to privacy. Okay. All right, so what is personal information? Some of the laws might call it personally identifiable information. Some laws might call it personal data. Some might say personal information. So it's any information relating to an identified or identifiable living individual. And that identifiable part is key because it doesn't mean that you need to know who the person is. It means that with this information, you could figure out who the person is. So if you have a birthday, an address, you might not know who that is, but taken together, you could go figure out who at that address with this birthday. Now I can identify who the person is. So don't think we don't have names, we're good, because it goes well beyond that. Personal information can be name, gender, date of birth, address, email, anything that you could associate with a person. The more information you have, the more likely you are to be able to identify that person. Going a step further, we have sensitive personal information. So this is data that carries a higher expectation of privacy. If you know somebody's sensitive personal information, then they could be at risk of losing their rights. And so it varies by law as to what's considered sensitive personal information. Traditionally, under US privacy law, sensitive personal information were data points that if stolen or if you misuse somehow, that could lead to identity theft. So think of a social security number, a driver's license or passport number, your bank account information. All of that is sensitive personal information under US privacy laws. In the EU, they had a different standard for sensitive information. So these are more of immutable traits that if you learn about somebody, they can be used for discrimination. So that's where you have sexual orientation, ethnicity or nationality, religious beliefs. As we talk more about the US state privacy laws, they are moving more towards incorporating these immutable characteristics in their definition of sensitive personal information as well. And then you also have non-personal information. So this is aggregated data. So if you have a list of 5,000 people's birthdays, just the date of birth, you can't identify an individual just from a birthday. And when you have a large grouping together, that you can't identify it from a list of birthdays. So when you have a large grouping together, it's aggregated data, it moves you out of this non-personal information. There's also this concept of anonymized data under GDPR and some other global privacy frameworks. Anonymized data is a very high standard to meet. You essentially strip all of the identifiable information so that it cannot be re-identified. There's also this concept under HIPAA. So if you have like a grouping, there's like a certain standard you have to meet. Sometimes you even need a statistician to kind of certify this is anonymized. You cannot re-identify this information. So once you have non-personal information, that actually takes you out of these privacy laws because they govern personal information. Okay, so privacy laws vary by region, by state, but they all have some core principles that they're carrying through their laws. So transparency. Individuals know what data is collected and how it's being used. Purpose limitation. You're only using the data for the specified purpose. So think back to how we talked about the doctor using your medical history to treat you. When you go to your doctor, you tell them your medical information. They can only use it for that one purpose. They can't then use it for something else. They like, well, we have these records lying around, let's do something else with it. That would be a violation of the purpose limitation principle. Data minimization, you only collect what's needed. When you're working with a company, sometimes they might say like, yeah, we're just gonna collect all this information, it'll be good to have, and you really have to dig in when you're working with them, like, well, what do you need it for? Let's only collect exactly what we need. Don't go beyond that. Accuracy. This idea that you can correct your information or it's kept current. So if you move address, like you can change your address. You can go to a company and say, I'm no longer at this address. Please update my information, keep it accurate. Storage limitation, you only keep the data for as long as necessary. Once you no longer need it, you either anonymize it or you delete it. Integrity and confidentiality, that protects against unauthorized access to the data. So we talked a little bit about data security and we'll dig into it later on, but this concept of integrity and confidentiality is that you keep that data secure. And accountability, if you are collecting this information, you are responsible for it. You must make sure you are complying with the privacy laws that apply to the information you collected. And if you have any downstream service providers or processors, you have to make sure they will also comply with the law. And they will only use the personal information that you give them for the purposes for which you give to them. So these principles kind of are the theme that go across all privacy laws. Okay, so let's jump into the US federal privacy framework. So in the US, we do not have a comprehensive federal privacy law. So there's no one law that governs how every company or industry must use personal information. Instead, we have a sectoral framework. So the laws govern a specific section of our industry. So you have HIPAA, which governs your health information. And this is very specific health information, which we can talk about later, but it regulates protected health information under the Act. So that's information that you're talking about with your doctor, they're sharing with an insurance company. It does not include information collected by your Apple Watch. So if you are having that if your watch is collecting your heart rate or anything like that, if you're using a period tracking app, something like that, that's not covered by HIPAA. And so that presents a gap that we'll talk about later how that's being filled. Then you have the Glam-Leach-Bliley Act, which governs the financial sector. This requires annual privacy notices. So you might get an email from your bank saying, or something in the mail, here's your annual privacy notice update. You have opt-outs, and there are safeguard rules. So they have to protect that information in a certain way. CIPLIT governs the privacy of children under 13 years of age. It requires parental consent for the collection of this data. We're also seeing a lot more enforcement in CIPLIT, which we'll talk about later when we talk about the FTC. The Fair Credit Reporting Act, we mentioned that was one of the first privacy laws that governs credit information. So, and that information, you have a right to update it, make sure it's accurate, you have access to it, things like that. So, and that can get very important if you are, yeah.
Can you explain more about OPA?
What about CIPLIT?
Yeah.
So that's a law that governs collection of children's data under 13 years of age. And so it's important that CIPLIT is under 13, and we'll talk about later, like how we fill that gap, because, you know, sometimes we think of like a child or a teenager is under 18, but CIPLIT is really specific to under 13.
Why don't they collect the data?
So if a child's going to a website, so we actually just saw an FTC enforcement action against Disney, that Disney was putting clips of TV shows and movies on YouTube, and they weren't saying that this is made for kids or directed for kid content. And so you can't target children with ads, so behavioral advertising against children is prohibited by these laws. And then you also need parental consent to collect information about children. So if when Disney wasn't saying these videos are for kids, they're posting Moana or Toy Story on YouTube, and they're not marking it as for kids, YouTube was, as part of their system, just collecting information about who was watching that, and that brought up information about kids. Think also back to the early days of the internet, and when kids were going online, so Penguin, was the other one, like GeoCities, so there was, you know, like those things where kids were going online, all of this information was being collected about them because these websites were clearly for children to play with. And so that's when Congress was like, this is not okay, these children don't understand the information and the impact of what collecting that information will be. So that's where they introduced parental consent requirements. Okay, and then FERPA. So this relates to education. So you're here at a university, what can DePaul do with that information? So there's accuracy rights, access, and consent. DePaul cannot just send out your transcripts to whoever you want. That's why you have to go through a process when you need your transcripts. Okay, so if the US has a sectoral privacy laws, how do companies outside of these sectors, how are they regulated? Any idea? Okay, so under the federal system, they're regulated by the FTC Act. So the FTC established the Federal Trade Commission. And so these are the key words from Section 5 of the FTC Act. Unfair or deceptive acts or practices in or affecting commerce are hereby deemed unlawful. Does anybody see privacy in that statement? No. Yeah, so it actually doesn't mention privacy, that the FTC would enforce privacy. But it has been determined through policy that anything violating a user's privacy is an unfair or deceptive act. So that's Section 5. And this has become one of the most important pieces of privacy law. This is where the FTC has found its enforcement authority. It's important to note it doesn't apply to nonprofit organizations and some industries. So Department of Transportation, banks, communications, they're all governed by different agencies. Okay, Section 6 of the FTC Act gives them the authority to conduct investigations and require businesses to submit investigatory reports. So that's kind of where they get their authority. So some of the common enforcement themes that we've seen from the FTC, are reviewing a company's privacy policy. And if you're not doing what you're telling people that you're doing, that's how they're enforcing that as an unfair or deceptive act. Dark patterns, which are manipulative little AI features or some kind of tricky subscription notices. So if you can't cancel something, that could be deemed an unfair or deceptive practice. And as we mentioned with HIPAA, there's a big gap in the types of health information that is out there, and HIPAA is limited to a certain industry. So the FTC has actually taken on covering health privacy that's outside the scope of HIPAA. So this could be apps collecting health data about you. And we're now seeing increased enforcement, and this administration's FTC actually said that they're very interested in children's privacy. So we're going to see a lot more CIPLIT enforcement from them. Also, the FTC will establish consent decrees with some companies. So based off its investigatory powers, the FTC may start looking into a company and saying, we don't like this practice, we're going to start investigating it. And a consent decree comes following an FTC settlement. So these consent decrees place obligations on a company. So they almost act as a specific privacy law for that company. And the obligations of the consent decree actually vary based on what the scope of the settlement was. If you fail to comply with your consent decree, there can be additional fines. There was a really interesting consent decree for Drizzly, which was like a alcoholic beverage delivery system that actually put obligations that if the CEO moves to any other company, the obligations of that consent decree follow him. So it can go beyond just the specific company. Interestingly, so this is happening more in the advertising or substantiative claims, but it could have impact for privacy. We're starting to see legal challenges that the FTC cannot enforce anything that is not explicitly stated in the FTC Act. So this actually came up through a case of substantiating advertising claims. But if that happens, if the courts say, actually, the FTC can only enforce what is explicitly stated in the Act, we go back to this, there's no privacy in the Act. So where does that leave the FTC with enforcing privacy should the courts deem that they don't have that ability? And also we'll see enforcement changes vary, or enforcement priorities vary by administration. Lena Khan was the former chair of the FTC. She was very focused on antitrust enforcement. We saw a lot of antitrust cases come out because the FTC also does antitrust. But now, like I said, this FTC has said they're very focused on children's privacy. So it can vary by administration and who the commissioners are. Okay, so we have very limited federal enforcement of privacy. So that brings us to US state privacy laws. So in the absence of a comprehensive federal privacy programs, states started introducing their own privacy laws. We talked earlier, California was the first one in 2018 with the California Consumer Protection Act. As you can see, the green states are states that have comprehensive federal privacy laws. Even beyond some of it, like Illinois has a biometric privacy law that's very specific to biometric information. So that doesn't fit into this tracker of the comprehensive laws, but there are still different laws within the states that you have to pay attention to. So this patchwork has been filling in the federal privacy law gaps, and they're moving towards a GDP-like framework. And we'll talk about the requirements of GDPR in a second, but we are seeing more of giving individuals this idea of giving individuals more control over their data, requiring more documentation such as data protection impact assessments. These state laws are also starting to define children as under 18 years of age. So we have that gap in CIPLIT where CIPLIT only regulates children under 13 years of age. These are filling in the gaps. So they're saying you can't target advertising to children under 18 years of age. You might need some additional language, or you might have to change the way you present something to a teenager because they might not understand it the same way that an adult would. You need more privacy protective settings when you're working with children than you are with adults. So you might think about that if you have a social media law a social media website and you have settings. For an adult, you could say like, we're gonna default public. For teens, you have to default private. So we talked about limitations on behavioral advertising. So you can't, there is often opt-outs of behavioral advertising. So if you don't want to have ads tracking you, you can opt out of that information. These privacy laws are enforced by either the state AG or some laws actually set up an independent agency. So California has its own agency that now enforces its privacy laws. So diving a little bit more into the CCPA, the California Consumer Privacy Act, it has been amended and updated so you might also see CPRA. It's all one big privacy act. But this gave users rights to access, deletion, correction, and opt out of the sale or sharing of their data. So this idea of sale or share really came through with CCPA and CPRA. So a sale of data is giving data to another entity for any valuable consideration. And if you do sell data, you need a do not sell or share my information opt out on the website. So a consumer can go there and say, do not sell my data. You have to pass that opt out on to anybody you do give data to. So if you have a if you have a data vendor, they give information out, you opt out of that, they have to remove your information from whatever data they're giving on to other companies. And these companies need to register as data brokers. So it's important to note that companies can provide data to their service providers, but when you have a service provider, you have to give explicit instructions as to what you can do with the data. And you have to make sure they are complying with that. So you might be thinking about a company that gives information to a payroll provider. They're responsible for sending out the paychecks every week. The company can give that information to the payroll provider as a service provider. They have a contract in place that says what the service provider can do with the data, and that service provider must follow that contract, and you have to monitor compliance. So this goes back to this accountability principle that we talked about. You can give this data to another party, but you are responsible for making sure they follow that. Yeah.
How do the state laws determine like who falls under the purview of that? Because is it the processors or whoever's collecting the data, or is it the users of who's giving the data? Like, how do they determine who it applies to?
Yeah, so there's usually a population and a monetary threshold. So if you collect 250,000 information about 250,000 California residents, or if you derive so much of your income from selling data, this law applies to you. And so that brings up a good point when you're advising companies on how to do this. Like, when you can look at this of like, all right, are we just gonna say we're gonna give privacy rights to everybody, or are we gonna go through the process of like which laws apply to us? Do we meet the threshold in Utah? Do we meet the threshold in Texas? Things like that. So that does actually present an interesting consideration when you're advising a company, because you could say, we're only going to have the requirements of the specific state law. That requires a lot of compliance checks. Is this person actually based in California, or are they based in Illinois? So it might seem easier to say, you know what, we're gonna give rights across the board. But that also brings up, if you're not doing that and you say in your privacy policy that you are giving rights across the board, and someone in Illinois is like, hold on, I opted out of the sale of my personal information and you're still selling it, but your privacy policy says that you will not, now you can actually get FTC enforcement because you're not doing what your privacy policy says. So there's a weird interplay between these laws that maybe the Illinois AG doesn't have a way to enforce this, but if you're saying in your privacy policy, you're doing it and you're not actually doing it, now you can have FTC enforcement. Some of the other states that have, some of the other big states, so Virginia has opt-out rights and requires data protection assessments. Connecticut has actually been very active in asking companies for their data protection or data processing assessments. So when you are doing something with personal data, you have to fill out this assessment that kind of states, what are you doing? What technical safeguards do you have in place? How are you securing this data? Was there a less intrusive way of doing this processing? Did you need to do it this way? How are you implementing user rights? How are you making sure that they can easily do this? So you kind of have to do all of this documentation, and if a regulator asks you, you have to turn it over to them. So yeah, so with this patchwork, it becomes a little complicated when you're advising, yeah?
Can the GDPR ever be applied to a US-based company that like collects European data?
Yes. So yeah, that's actually a great segue. So getting into GDPR does have an extraterritorial scope. So if you are collecting data of EU citizens or EU residents, you have to comply with GDPR. The fines under GDPR are about 4% of your global turnover, depending on how they view the non-compliance with GDPR. And so with this extraterritorial scope, you actually see a lot of companies moving to a GDPR standard. And that's why in 2016, when GDPR came out, it was the first time a lot of companies looked at privacy laws because they suddenly had to comply with this law, even if they weren't based in the EU. GDPR also implements this one-stop shop idea. So if you have offices in many different countries within the EU, or many different EU member states, you really don't have to apply to one supervisory authority. So the supervisory authority, if they ask for your data protection impact assessments, you turn them over. They're the ones leading the investigations against you for fines. So you set up your residence or your headquarters within one EU member state, and you only have to talk to that supervisory authority. So you don't have to talk to, if you're based in Ireland, you don't have to talk to France, Spain, Germany. All of that will feed through the Irish regulator. GDPR also established the concept of having data protection officers. This is an independent person in your company who oversees your compliance with the law. And so the key part about them being independent is they can come to you and say, this is not compliant with GDPR. And they have protection, so you can't just say like, well, we don't like that, we're gonna fire you and bring in somebody else who says it's fine. So you have data protection officers, and they have to sit in your main office, whichever supervisory authority you're reporting to. The other key thing with GDPR is that you can only process data if you have a legal basis under the law to process data. So in the US, we have a lot of opt-out regimes. So companies can process your data until you say stop. GDPR, you have to have a legal basis to process that data. If you don't have a legal basis, you can't do it. And so there are 6 legal bases. The most common ones are consent, but consent is actually very hard because it can be revoked at any time. You can say, I no longer want you to process my data this way. So it's actually not what most companies rely on. They look at a legitimate interest to process the data. And that's a whole balancing test of, is what you need to do with the data, does that violate the rights and freedom of the person? And you have to fill out a legitimate interest assessment, which ties into DBA. So there's a lot of documentation within this law. Following Brexit, you also have UK GDPR. So GDPR, when it came out, the UK was part of the EU. Since Brexit, they have implemented their own GDPR, and they have adequacy. So adequacy decisions are between the EU and different countries that the EU will look and say, your data protection laws are sufficient for us to send EU data that way. So Japan is an adequate country. So if a Japanese country is processing EU data, they can transfer the data to Japan for the processing without any additional documentation. The US, we don't have a federal privacy law. We are not adequate under GDPR. So we've had different mechanisms in place that allowed the US companies to process EU member state data here in the US. The first one was the Safe Harbor program, that was invalidated. We had the Privacy Shield, that was invalidated. And so then we relied on standard contractual clauses. These were clauses that got added on to your data protection amendments. It had all of the requirements. And so we could send data between the companies as long as we had the standard contractual clauses. So what the company receiving the data or what the company based in the US could do. Those were invalidated. So now we have a new framework that companies that abide by this standard, the company themselves are kind of deemed adequate and they can process EU resident data. There's a challenge. We'll see if they're invalidated. This kind of goes back to some of the things we talked about in the beginning with that dynamic between national security and sending data. So a lot of these frameworks have been invalidated on the idea of the access that the US government has to the data from companies based in the US. So it almost kind of feels like the GDPR might be like saying, hey, your national security law is too much, but we're not looking at our own national security laws. Some other laws, so we have PIPEDA in Canada. Canada has proposed a new privacy law to be updated with some of the technology changes that have come across in the past decade, but so far that has not been enacted. LGPD in Brazil is very similar to GDPR. The PIPL or PIPL in China, it's pronounced so many different ways. The key one with that is it has highly restrictive data export controls. So you really can't move data out of China. And then in India, we have the DPDP Act of 2023. So we're still waiting on a lot of rulemaking as to what that law would be, but it actually establishes this data fiduciary model. So if you think of, are you familiar with fiduciaries in the US? I think a lot of times we have them in the context of the financial sector, but you now have this data fiduciary idea coming out of India's privacy law. So a big thing with these privacy laws is that they have very similar themes, but the enforcement is going to vary differently between the laws. And you tend to see a lot more in terms of a bite enforcement authority under GDPR and some of the global laws. So the largest fine under GDPR to date was $1.2 billion. Under the CCPA, the largest fine was $1.55 million. So this is why a lot of companies have really shifted and focused on like, how do we comply with GDPR if we are a global company? Also with GDPR, if you're complying with that, you're like 80% of the way there with the US state laws, because again, they're kind of going to this GDPR light framework. You will have to do some additional things, but you're mostly there. So the focus has really been on, at least from what I've seen, moving to this GDPR compliant state. Any questions on like the state or global framework before we move on? Okay, cool. All right, so let's talk a little bit about data security and breach obligations. So because of the impact to personal information, this is often part of privacy law, but data security safeguards include administrative, technical, or physical safeguards for protecting the data. Administrative, blocking off who has access to the data, technical safeguards, such as firewalls, ways to prevent other people from accessing your systems. And then physical safeguards, this could be like protecting your data center. So do you have fire suppression? Do you have a way to get your systems back online if you were hit by a hurricane, things like that? You have the NIST framework. Identify, protect, detect, and respond and recover. So this is a security framework meant that you can align your system with to make sure you're able to respond to data security threats. So common failures that lead to impacting your data security. Phishing scams. You get an email that says, click here and reset your password, but really that gives somebody your password so they can get into your system. Misconfigured cloud storage or not patching software. If you ever had a company computer or something and it says you need to update your operating system by this time, that they're trying to patch their software, making sure there's no vulnerabilities. A lot of data security incidences stem from companies not properly patching their software. There's a known vulnerability, a bad actor can use that to get into the system. And then insider threats. Somebody in the company decides to steal data. When you're working with companies, it's important to know this isn't necessarily about personal information. We're actually seeing a lot of ransomware or bad actors targeting company information. I think there's kind of this idea of there's been a lot of data breaches. Most of the information is probably already on the dark web somewhere, but your company's secrets are more valuable at this point. If you do have a breach that leads to personal information that's stolen, you may have to notify users. So there are 50 different state breach notification laws. We don't have a federal breach notification law. It varies as to how many people need to be affected before you notify, what information has to be stolen, what information has to be accessed before you notify, how you notify. So sometimes, depending on the amount of people, you can send a personalized notice, so sending an email or something through the mail that says, we've had a data security incident, your information may have been impacted. Some of these laws require that they provide credit monitoring services or something for you to do to kind of keep an eye out, make sure you're not further impacted because this information was accessed. If it's a massive breach, you might see it on the news. And that's one way of saying, like, we need to reach as many people, like we need to reach everybody. We'll announce it on the news, we'll announce it on our company website, things like that. Under GDPR, you have 72 hours from the time you become aware that personal information was accessed in a data security incident. So there's really a big clock on these. When you're working on data security incidents, they're kind of around the clock work. There's no like, okay, well, it's 5, I'm going home today, we'll pick this up tomorrow. Like those rooms are constantly working to understand what was accessed, how the person got in, if they actually have the information. Did they take a screenshot of something and now you have a ransom note with just a screenshot, or did they actually access files and remove them from your system or lock them down? When you are working, when you have a breach, you want to make sure you bring in specific forensics experts and you're working with them under privilege. So you want to bring in an outside counsel and a forensics agency to kind of do this analysis. So make sure you can do this investigation under privilege. I think the scary thing, it's not a matter of if your systems will be breached, it's a matter of when your systems will be breached, or excuse me, breach is a term of art, but it's a matter of when you're going to have a data security incident. So you really want to work closely, privacy councils really want to work closely with their security teams to make sure they're doing everything they can to minimize the impact of data security systems or data security incidences. All right, we'll touch briefly on artificial intelligence. It's a CLE in the year 2025. This is a requirement. There are some challenges coming up with artificial intelligence. Training AI models requires a massive amount of data. Sometimes it's personal data. There's often a lack of transparency as to how the model is doing its decision making. So you're not really sure about what's going on, and you can't provide that transparency of, we're going to use your personal information in this way. The models just don't allow you to understand its reasoning. There's a risk of bias or discrimination. Many privacy laws have this concept of prohibition against automated decision-making technologies or using an AI tool that would make automatic decisions of legal effect. And that of legal effect is important. That could be something like hiring somebody for a job or analyzing a loan application. It doesn't mean that you can't have artificial intelligence tools But you need to make sure you have some human oversight into what's happening. So if you have a tool that reviews loan applications, having the AI tool review that, you need some sort of human going back, checking, like, is there bias or discrimination in the way this model is providing this? Data leaks. So models are continually learning from the conversations with users. So there's this they could take something that you're talking to ChatGPT about and then use that information in responding to somebody else because it's still learning on it. In the corporate context, this could trigger data security obligations that we just talked about. Samsung banned any use of AI models after one of its employees uploaded the code into ChatGPT, and then they were worried the code was going to be given out to somebody else who was using the model. And it's difficult to apply the consent and data minimization principles that we had talked about. It takes a lot to untrain a model. Model disgorgement essentially takes away your entire model and you have to start back from the beginning of training it. So if you give your consent to a company, this is why many companies don't rely under the consent as put in GDPR, because that consent can be revoked at any time. If they use that data that they had based on consent to train a model and you revoke consent or you withdraw your consent, how do they pull that out of a model training? And it's not as simple as, all right, we're just going to delete your account with an AI tool, or we're going to delete your conversation. Because of the retraining that's constantly happening, it's very hard to say that data has actually been taken out. Because of AI, we've also seen some regulatory developments. We have the EU AI Act. There was the US AI Executive Order, and we're starting to see FTC and state AG enforcement and some state law rulemaking. So Colorado recently issued a rulemaking related to their Privacy Act of what that means for AI. We're not really sure, as we're kind of developing, as these regulations are developing and you're advising teams on this, it's important to stick to those common core principles that we talked about in the beginning. The AI laws are going to change, how they're going to be enforced, like time will tell. But if you're advising based on these common privacy principles, you have a really good starting point. Okay, so now let's get to the hypos because we have about 10 minutes left. Okay, so we have an AI hiring tool. A company headquartered in California with offices around the world uses AI trained on historical employee data to screen applicants. The data set includes demographic and educational data. So what privacy risks do we have? Yeah.
So basically, like it will impact on, like it will be kind of, reach the GDPR first because it's a one world, and there is also a California office, California with the offices around the world. So, like the two law might be there. The first one is the CCPA and second one is GDPR. And if something is related, and education data is also there. So, like if someone under the 13, so COPA will be there and
So yeah, good job. So because it's headquartered in California, you definitely have the CCPA. Offices around the world, you are implicating GDPR, could have some of the other global privacy laws depending exactly where the offices are located. So if you have offices in Brazil, you got LGPD. If you have offices in Canada, could impact PIPEDA. Okay, so yeah, so those are the privacy laws that apply. Some of the privacy risks that you have. So you're training your model on employee data. Did employees, when you collected that employee data, did you say you were then going to use that to train a model? This kind of goes back to our purpose specification principle. If they did not give the data to you for the purposes of training it for a model, you might not have that right to train the data. Also, if you're training it on demographic and educational data, you could have risks of bias or discrimination. So if the model starts to learn everybody in the company came from Harvard Law and they see Stanford Law on an application, they could say, no, that doesn't fit with the employees. So you could have bias that way. And then automated decision-making technologies for legal effect. Hiring for a job is a legal effect. That is something that would significantly impact somebody's life if a tool was making the decision without human oversight. So you would need somebody to kind of oversee use of this model, making sure that it is not throwing out applicants based on where they're located or their educational data simply because it doesn't match the people that were part of the data set. Yeah. We'll start with you, yeah.
I noticed actually when some like recruiting companies, they are trying to get applications, they do have the like question, would you consent the data collected will be used for product training? And if you did not check it, like you cannot proceed to use the application. Seems like they provide an option, like you have to consent. How do you like, what do you think of that kind of consent? Is that consent valid or is not?
So it depends, yeah, so that's an interesting one. So the question was, if you have to consent to use of your data being used for training a model before you can apply for a job,
Right.
is that valid consent? And so it depends on like your privacy law. So under GDPR, that would not be valid consent because you can't withhold something on the basis of consent. You're essentially forcing somebody to consent. So that's not deemed valid. It has to be a true choice under GDPR. I don't know how those companies are doing, like I don't know the specifics of that, so that'd be really interesting. But yeah, so there's not like the companies, if they're collecting consent, they can use these AI tools. There's nothing against actually saying you can't use an AI tool for hiring, but you need to make sure you have human oversight. You're addressing these biases or discrimination risks, things like that. So you're not just relying on this tool to make the decision for you. Do you also have a question?
I want to add one point over here when it comes to the privacy risk. When we highly rely on the recruiting process for LLM tool, right? So sometimes we will see some, like a bias result when it comes to the gender bias, right? In specific industry specific role, so it gives some, like a different sense about that. Like in some domain, it shows like this like male should have to go for this rate or salary, and some other domains goes to the woman should have to this kind of salary. It's kind of a gender bias that also seen in the many of the outputs from the LLM tool.
So, sorry, I had the train, so let me just make sure. So you're talking about some of the, were you referring to the gender bias studies where like they stripped the name from the resume or?
Yeah, I like if the organization focus on the LLM recruiting process, right? So most of the times if we fill the data, the tool will respond back to us as per the data and shows that like some kind of gender bias in recruiting. As per the like sometimes it also it has been seen that like the huge gap between the range of the salary between the.
Yeah, and so this goes back to the like lack of transparency into the reasoning of these models. Like you don't know why the model is saying, oh, a woman should have this starting salary or a man should have this starting salary. And that's why human oversight when you're using these models is so important, especially in context of like hiring, anything with that kind of like significant legal effect. Okay, I think we'll get one more in. All right, so we'll talk about data vendors. So data vendor provides segment data to advertisers to help the advertiser better target potential customers. So is this data vendor selling or sharing personal data? Yes. Yeah, so if you are giving a segment data to an advertiser and that advertiser can go off and do whatever they want with it, then that is a sale of data. What obligations does the data vendor have? So they would have to register as a data broker. And then with that, if somebody opts out of the information, they have to remove them from the segment. What obligations do the advertisers have related to receiving data via sale? So they bought data. Do they have any data obligations? Yeah.
If someone opts out of the original, it would flow through to them, right? So they have to like stop using that data.
So the data vendor, yeah, the data vendor should notify them, like, this person has opted out. There's no prohibition on buying data. However, once the advertiser has that data, that's personal information, they have to comply with the personal information laws that apply to them. So they have to comply with any privacy laws that govern their company. So yeah, you can buy data, but then once you have it, you're a controller, you're the business owner of the data. So you just have to make sure you are compliant with the privacy laws once you have that data. Okay, we are almost at time. Just some resources if you're really interested in privacy. The IAPP is a great way to stay up to date on changes in the law. Future Privacy Forum, they have really good email news blasts about any amendments coming through, any changes in the law. You can read up on the NIST privacy framework and the EU Data Protection Board. They release a lot of the case law related to EU fines. Okay, any questions? Yeah.
Do you know of like any or the biggest example of an AI model having to be disgorged because of lack of consent or any other reason?
There was an FTC case, 2023. I'm trying to remember what it was. I believe, so I think it was like a photo repository website was giving, I don't remember which company it was, but it was giving, people are uploading their photos. They weren't told that the models were being trained off of like the facial images within the photos. And so that model had to be disgorged. In terms of like, I have not seen anything with some of like the big names, like a ChatGPT or Claude or anything like that. But I can look up the specific company.
Any other questions?
Yeah.
If you were the in-house counsel for a global company, which privacy law would you recommend to use in their contract as the governing law?
So the question was, in-house counsel for a global company, which governing law would you use as for the contract? So you, for the most part, you probably use wherever you're headquartered. So if you are like based in Illinois, you would use Illinois as governing law, but that doesn't mean that, so for your contract, that could be governed by one law. That doesn't mean the privacy laws are not applicable. So you can't contract away, we will not comply with CCPA. If you meet the threshold for CCPA, you still have to comply with it, even if your contracts are governed by Illinois law. Does that make sense?
How, I was wondering like how to deal with the possible conflict of laws. Especially like mentioned, even if it's like contractual, governing law still should abide by the privacy laws based on where the business operates.
Yeah, so privacy laws it's not necessarily based on the location of your company. It's based on the data of the people you collect. So if you're collecting, even if you don't have an office in the EU, but you are collecting data from EU residents, you still have to comply with GDPR. And that's all of the state privacy laws, the US state privacy laws have like some threshold. So if you're collecting so many people who live in that state, you're collecting their data, or you make a certain amount of your like revenue from the sale of data, those laws apply to you, whether you have offices there or not. And you can't contract that away. And if there's any, like California can't come in and say, we're going to enforce CCPA on the data from Illinois residents that you've collected, but they will enforce it on California residents. So if you have, and so fines are based off of whatever the like violation is. So it's like $5,000 per violation, and you have X number of California people, the fine would be based on that. It wouldn't be based on the whole like Illinois residents as well.
Okay, I think, do you have, Alice, okay. I think we're at time. Thank you so much for doing this, and, yeah,